We're on the record in case 24, CRI 236, caption State of Ohio versus Robert. Is it MICHALSKI, sir?
Yes, ma'am.
We're here for purposes of a bond setting on a complaint that was filed earlier today. The defendant is present. We're conducting this hearing by video, appearing on behalf of the State of Ohio's prosecuting attorney, Christopher Tennell. Mr. MICHALSKI, do you have any objection to the court conducting this hearing by video?
No.
Did you get a copy of the complaint that was filed?
Yes.
The court has to go over that with you. There's 2 counts in the complaint. Count 1 is endangering children, a felony of the 2nd degree. That reads on or about August 17th, 2024 in Ashland County, Ohio. Robert MICHALSKI Jr. did administer corporal punishment or other physical disciplinary measure or physically restrain the child in a cruel manner for a prolonged period, which punishment, discipline, or restraint was excessive under the circumstances and created a substantial risk of serious physical harm to DM, date of birth 11/4/2017, a child under 18 years of age, date of birth 11/4/2017, in violation of Ohio Revised Code Section 2919-22B3, 2919-22E3, endangering children, a felony of the 2nd degree. And it reads furthermore, the violation resulted in serious physical harm to DM, date of birth 11/4/2017. Do you understand what the state is alleging in count 1?
It's saying I punished the kids. I didn't punish the kids.
Okay. It's just an allegation at this point, so you don't have to agree with it, but do you understand what they're alleging? You understand what the
Yes.
charge? Okay.
Yes,
All right.
ma'am.
Count 2 is tampering with evidence. That's a felony of the 3rd degree. That reads on or about August 17th, 2024 in Ashland County, Ohio, Robert MICHALSKI Jr. did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation in violation of Ohio Revised Code Section 2921-12A1, 2921-12B, tampering with evidence, a felony of the 3rd degree. Do you understand what the charge is and what they're alleging in the 2nd count of the complaint?
Not really. I don't understand.
Okay. Do you have any questions about what the charge is? It's saying that knowing that there was going to be an investigation, you removed some piece of evidence or document, thing, object involved. That's kind of the nature of the charge. Do you understand that?
Yeah.
Do you have any other questions about it?
I can't think of any right now.
All right, the court has rights to go over with you. First, you have the right to remain silent. Anything you say during the course of this hearing could be used against you at future hearings. You have the right to have an attorney, and you have the right to a court-appointed attorney if you cannot afford to hire one, and if you qualify. There's a $25 fee for court-appointed counsel. You also have the right to have a preliminary hearing, which is a probable cause hearing since you're charged by complaint. And you have the right to have a jury trial and to have the state establish your guilt beyond a reasonable doubt to 12 jurors as to the charges. Do you understand those rights as I've explained them to you?
I think so.
Did you want to be represented by a lawyer?
I don't know. Do I need one?
You have the right to have one. You're not obligated to have one. It's a felony of the 2nd degree and a felony of the 3rd degree. So if you qualify for a court-appointed attorney, then the court could appoint an attorney to represent you if you want that.
Is that what I should do?
I
I've never been through this.
can't tell you what you should do, but if you have questions, an attorney could answer them for you. Do you want me to consider you for a court-appointed attorney?
Yeah, if he could explain it better. Yeah.
Court-appointed attorney would just represent you regarding the case and explain your legal rights to you. You understand what an attorney can do for you?
No, I don't understand.
Okay. You've never had an attorney before?
Just with my abuse case with my ex-girlfriend.
Okay. So if I
Trouble.
appoint an attorney, they'd explain the process to you, the procedure, the charges, how the court works. That's kind of what an attorney does, is protect your rights or explain your rights to you. and help you through the case. Okay.
Yeah, I need that.
Okay.
I don't understand very well.
Okay. I have to ask you a few questions then about your finances to see if you qualify for it.
Yes, ma'am.
All right. First of all, is your address 23 Chapel Street in Savannah?
Yes, ma'am.
What's your date of birth?
12/2/1976.
Okay. And the last four of your social? Okay. You have a phone number?
I can't remember it. I never call myself. I just got a new phone number.
Okay. Anybody else live with you at your address on Chapel Street?
Currently, my niece,
Okay. Can you give me her first name?
Angelina Rose.
And is she over 18, under 18,
I'm not sure. I think so.
adult?
I believe she's an adult. I'm not really sure.
Okay.
I don't know how old she is, if that's what you want.
Anybody else live with you?
No. My dogs, that's it.
All right. Do you receive any benefits like Ohio Works First, SSI, SSD, Medicaid, food stamps?
I get food stamps and disability.
Okay. Do you have any checking, savings, or money market account?
No. I have like my account that my social security goes into, yeah.
Okay.
But have backup money, no.
Okay. Do you know what the
25
approximate?
$25 is in my savings, and I think 100 and something's in my check
Okay.
right now.
All right. Do you have any stocks, bonds, or CDs?
No, ma'am.
Okay. Any other liquid assets or cash on hand?
No, not that I know of.
Right. You do qualify for court-appointed counsel. Court's going to appoint Attorney Donald Wick to represent you. We'll let him know that he's been appointed and he'll be at the next hearing. We'll give you a chance to talk to him before we get that hearing started. Okay. We are going to address the matter of bond today. Attorney Tennell, the state's position on bond.
Thank you, Your Honor. Your Honor, as best law enforcement can tell, and it's still a rather fluid situation, and it's complicated by very few truthful statements being provided by the folks that were present. It appears that Angelina Williams, referenced by the defendant, is residing at his house. She's also a charged co-defendant in this. Came to his house a week or 2 weeks prior to Saturday, August 17th, with her two young children. During their stay there, they were provided handcuffs that belonged to this defendant, or at least were there previously in his residence. And as some form of discipline, the adults in the house have either or both tied both children with rope to a chair and or handcuffed the children. On this particular occasion, on Saturday, the 6-year-old, there was a disagreement over his picking up dog excrement in the backyard that resulted in his being cuffed, both his hands by one set of cuffs and his feet being a second set of cuffs. There's a further allegation that there was an attempt being made to then tie him to a chair when he ended up on the floor during that process. As he ended up on the floor, the pit bull that also resides at that residence and belonging to this defendant attacked him by essentially latching on to the boy's neck, causing severe injuries to the child, who was unable to defend himself due to the restraints. The boy was then uncuffed, and the dog, it took upwards of 4 adults to remove the dog from his neck. 911 was called, and an effort by some of the adults was made to apply pressure and seek medical care. This defendant took the dog in question, put it in a car, despite the defendants not having any valid driver's license, and spirited the dog away to an acquaintance who resides in Mansfield, asking him to keep the dog for a period of time and he would come back. Eventually, this defendant, once the police had left later in the night, did go back, pick up the dog, and brought it back to the house. A search warrant was executed on the house on Monday, which located 2 of 3 pairs of handcuffs that law enforcement believes exist, and finding the dog hidden 3rd floor of the residence. And this defendant admits that he hid the dog and took the dog out of the house. When questioned by law enforcement on Saturday, he had a story about the dog running away, and then just miraculously reappearing at his house and putting itself in a crawl space area on the 3rd floor, all of which is clearly untrue. The other adults in the house met deputies and a responding squad in Savannah, where the boy was then taken to hospital in Mansfield and then taken to Akron Children's, where he received treatment and has miraculously survived the neck injuries. This defendant doesn't have any prior criminal history. The state can find at this time. In addition to standard bond conditions, the state would ask for no contact with DM, the listed victim, the DM's sister. There's a custodian to these children. We're still trying to get to the bottom of what's going on legally with that situation. It does appear that mother had some residual visitation rights and that the children were on summer visit with mother, and that's how they came to be here. No contact with any minor for that matter, and that he's not to possess or be near any dogs. Further, we'd ask for no contact with the co-defendants, Angelina Williams or Tyler, let's see, Tyler is Marvin Brown. So Tyler Marvin Brown, charged co-defendant. And we'd ask for a cash bond in the amount of $150,000, Your Honor.
Thank you. Excuse me, thank you. Mr. Michalski, is the court's going to remind you that you do have the right to remain silent. So you don't have to say anything today regarding bond if you don't want to. If you want to talk to your lawyer first and have your lawyer talk for you at the next hearing, then that's fine. Is there anything you'd like to say today just regarding what the court should set for a bond?
So I don't know what to say.
Okay. It's all right. You don't have to. You don't have to say anything.
Yes, ma'am.
Right. The court's going to set bond as follows. To be released, you'll have to post 2 bonds. The first is a personal recognizance bond. That's your written promise with the court to appear at all future hearings in the case. If you fail to appear, you could be charged with a separate felony offense. The second would be a surety bond, bond secured by real estate or the deposit of cash in the amount of $150,000. Conditions of bond are that you not leave the state of Ohio without written permission from the court. Keep the court informed of your current address and telephone number at all times. Follow and obey all laws of the state of Ohio and orders of the court. Cannot use, consume, or possess any drugs of abuse or alcohol, and you'd be subject to random drug and alcohol testing. Cannot use products containing THC while you're on bond. After you post bond, you need to report to the court's bailiffs. Their office is across from the hallway. Clerk of courts. They'll get you enrolled in the court's drug testing and bond program. Court's going to order that you have no contact with the alleged victim listed in the complaint in this case, or his sister or his custodian. Court's going to order you have no contact, means no contact by phone, online, social media with either of the co-defendants in this case, being Angelina Williams or Taylor Marvin Brown. Court's going to order you have no contact with any minor child. Court's going to order that you have no possession of any animals, including dogs, while the case is pending. Do you have any questions about the conditions of bond?
Now my muggins,
Say it again.
my little muggins, you said I can't have dogs.
Correct. You cannot have possession of dogs during the course of the case. That's an order of bond. So if you do, you could be returned to jail if you bond out.
You're not gonna kill my muggins, are you?
I don't know about that at this point, sir. And you can talk to your attorney about that. Future here. We're going to set another hearing. Could try Friday morning. You can do Friday at 9 o'clock. Works for you, Attorney Tennell?
We'll make it work, Your Honor.
Okay, we're gonna try to schedule you for another hearing this Friday at 9 a.m. That'll be an initial appearance hearing. If you bond out, come to the courthouse for that hearing. If you don't bond out, if you're still in jail, then we'll have you by video again. But like I said, we'll give you a chance to talk to your lawyer privately before we get started. Okay?
Yes, ma'am.
All right. Anything further, Attorney Snell?
No, ma'am.
All right, thank you. We're adjourned for today.
Recording stopped.